What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace because when she comes back in here, it is gonna be a mess. State your names.
Carla Green. That's what
Dustin.
All right, where are we on this, folks? Because,
I filed the proper paperwork.
well, I don't know that you did. Okay, so here's the problem. I don't think that I have subject matter jurisdiction over the case, and let me just explain it so everybody knows what I'm talking about. In order for the court to obtain subject matter jurisdiction over the case, I have to have a proper notice to quit. When we were here, and I kind of explained it the last time that we were here. When we were here the last time, you were indicating to me that you gave them a notice to quit on the case. I didn't have it in my file. And I kept asking you, well, when did you serve it on them? Because I think they were saying they hadn't gotten a notice to quit. So I said that I had to have the one that has the proof of service on it. And I adjourned it out to give you an opportunity to correct that. Because if it had been served, it was. So you filed with the court a notice to quit. And importantly, on the notice to quit that you filed, it says that they had to move by February 28th, 2025. And that you served it on them March, as I'm looking at it here, March 10th, 2025. Is what it looks like to me. And it says it's served by first class mail. Assuming this document to be true, I don't have jurisdiction over the case. And in fact, I'll just say this, this document, if that's the March 10th date, it can't be true because you can't tell someone they have to move by the 28th of February and not give them notice that they have to move until March 10th. The only way that this notice, as it is signed by you, can make sense is if it were served on them on March 10th, they would have until April 11th or April 10th in which to move. So when I look at the face of the documents, this notice is invalid. With the dates that are on here, it can't be true.
Additionally, went with that notice to quit, had this file, had the police officer do it the correct way, because that's what I was told to do from this court. The notice to quit. You said that I had to show proper paperwork of me serving them the correct way. So the first time I served them was
And we went through this the last time. You gave me, and when you were talking about the police officer serving, that's the service of the summons and complaint. That I don't necessarily, as I'm looking at it, have a problem with, that they would have received a summons and complaint from the court. They would have had an officer or somebody show up to serve that. That I'm not having the issue with, and that's what I was trying to explain at the last hearing. Because the document you handed me, that you were talking about that. What I told you was the notice to quit. I didn't have a copy of when it was served on that. Gave you the opportunity, you said you did, I gave you the opportunity to correct it. I'm not sure what date it was received, but the document that we received that was received by the court is a notice to quit to recover possession of the property. I will say two things about that. First of all, it doesn't match. The top portion of that notice to quit does not match what I have in the file, which leads me to believe that it's not the document that was served on them if it was served. Then even aside from all of that, and so in reality, it's not a valid notice to quit. But even aside from all of that, if I were to say, I'll give you the benefit of the doubt, I'll just look at it, I'll take the dates. You can't give somebody a 30-day notice, tell them to move by February 28th, and not tell them until March 10th.
Your Honor, I think it's a misunderstanding. I served them a notice to quit on February 28th because I'm following all the court steps. She said, first of all, you have to file a notice to quit yourself. And then if they don't move, you come to court, you file this paperwork, and then you come to court. So I served them, correct?
No, you don't get the question. What are you saying? You have to give me a proper service here. And I don't have it. I don't know what that notice to quit. You keep saying that you gave them one. I don't know what it says. Because your two notices to quit are different. The one that you gave me just recently is different than what was attached. The top portion is different than what was attached to the complaint that was filed. One is typed, the other is handwritten. It says move by the 28th, but the way it works on a 30-day, I tell you, if I were to give somebody right now a 30-day notice today, the 18th, I would say, if I serve it on somebody today,
Your Honor, I served it on January.
just don't interrupt me. April 18th, I would give them until May 18th to move.
Correct.
Your notice, on the other hand, says you have to move by February 28th, but I don't tell you that until March 10th.
That's the second.
Can't work that way.
That's the second notice, Your Honor. The first notice, they told me to serve it. You have to have a 30-day notice to quit. I served them the 30-day notice to quit January the 28th. So they had till February the 28th to move.
Then why don't I have a proof of service that it was given to them on January 28th? I don't have that. I told you to come back, and usually I wouldn't do it. Usually I would have kicked this case the last time. You kept telling me that you had it. I see a notice. I don't have the proof of service on the notice to quit. I gave you an opportunity to correct. What I got
Your Honor,
is an impossibility.
Your Honor, what you got is what the court told me to do. They said file a 30-day.
You're not going to blame the court. The court didn't tell you to do this, because I think this is a falsified document if you want to really get down to it. Because the notice to quit that I have in the file is typed. The notice to quit that you gave me is handwritten. It can't be the same. I don't want to accuse you of providing false documents to the court, but that's certainly what it looks like. And secondly, the date, as I indicated, and I will say, you can smile at me all you want, but I'm going to tell you right now, if I think you filed a false document, you're going to get a show cause, and you're not going to like what happens. Am I clear? The document that you gave me is a factual impossibility. You cannot tell somebody to move February 28th and serve them on March 10th. It can't happen that way, because you're telling them to move after the time that you told them to move. You can't do it. That's what's in this file. So giving you an opportunity to do that, I've given you an opportunity to correct it. You failed to correct it. I will state on the record, I think you provided to the court a false document. This court lacks subject matter jurisdiction pursuant to the cases decided by Michigan Supreme Court. I don't have jurisdiction over this case. The only thing that I can do is dismiss it. This case is dismissed for lack of subject matter jurisdiction. What'd you say? Ma'am, you better bring her back here. Bring her back here, Alan.
Your Honor,
Yeah, go back there someplace, because when she comes back in here, it is gonna be a mess. State your name.
April Joy Fleming.
Your Honor, I am asking for hopefully one last adjournment. We've been adjourning for medical records. We did get some medical records are waiting for records from Trinity Health. Hopefully I can get that mitigation over to the people and come to it.
Ms. Fleming,
Yes,
were you huffing on Zoom?
I'm sorry.
Were you huffing?
No, I was not.
Are you sure?
Yes,
So if it was reported to me by two people that you were, they wouldn't be telling the truth?
I don't understand what you mean. Was I huffing when?
Today.
Today? No.
Where do you live?
I live at Chittister Place Apartments.
How long will it take you to get here?
I don't have a ride or anything. I don't know. To get there today?
Yeah, today. We saw you doing something you probably shouldn't have been doing.
What do you mean, sir?
Were you huffing?
Was I huffing just now? Like on camera? No.
Okay, today, off camera, on camera, you've been huffing?
No.
Not at all?
No.
So if you came down here and I sent you over for a test, everything's gonna come back negative?
Yes.
It will?
Yeah.
Okay, you're gonna need to find a ride. I'm gonna need you down here.
Okay, sir. I don't know how I could get there.
Ms. Fleming, I'm gonna give you a call, okay?
Okay.
Thank you.
Thank you.
Fleming, say your name for the record, please.
April Fleming.
All right. Well, thank you for coming down. Miss Fleming, I'm gonna ask you again.
I did. I was.
You did what?
I huffed.
You were huffing. Yeah.
I'm sorry. I made a mistake.
Why weren't you? Why were you lying to me when?
I panicked. I just panicked. And I'm so sorry. I'm really, really sorry.
Ma'am, how frequently are you doing this? I mean, are you doing that every day?
Sometimes.
I mean, you're gonna end up dying.
Can you give me
I
another
mean,
chance today, please?
Is that what you're trying to do? Are
No,
you trying to kill yourself?
no, I'm sorry. I just,
Okay, but how long have you been doing this?
I don't know. I've tried it off and on for a year or so.
Have you thought that you might need to get into some type of treatment or something? Have you?
I need to,
But you haven't done that.
I guess I haven't had anything like this happen. I plan on getting in touch with,
Who are you going to get into? You don't even know.
huh?
You don't even know who you're going to get in touch with.
Well, I know I have to speak to,
Well, I will say Miss Fleming does go to therapy at Huron Valley Consultants.
yeah.
And as I've stated, we've been working on getting those medical records. I have reviewed some of those medical records. It indicates they do talk, and Ms. Fleming's on methadone. Are we still in the methadone program? So I do know, I will say that there are entries that they've had these types of conversations about her past use. So I think it's something that Ms. Fleming knows that she deals with.
Yeah.
Have you told them that you're huffing?
No,
You
I-
haven't.
I know I have to. I
Sure.
plan on speaking to my counselor today.
When's the next time you see your therapist?
I can see him tomorrow morning.
Okay, so Miss Fleming, here's what you gotta understand. For me, when you tell me that you have an appointment, when you tell me all these things, it becomes hard for me to believe whether or not you're telling me the truth.
I understand that.
And that's because I asked you a series of times when you were on Zoom.
I freaked out. I should have said the exact truth, and I'm so sorry, Dustin, and please give me a chance today, please.
Well, Miss Feltus, you want to say something?
I do, Your Honor. Miss APA Cook was able to review the YouTube footage, and we shared with Miss Kearney a screenshot that did show the defendant with the canister in her hand. I recognize that canister to be what I commonly referred to as dust off or computer cleaner, a type of compressed air. I'm very familiar with this drug, and I know that any time that you use it, it can cause instant death. This is a drug that is extremely dangerous, and the way that this is being ingested can lead to long-term issues as well as immediate death. The brain can die every time you do this. I think it's clear the defendant's very scared. I think it's clear that she wants to change. She wants to stop using. I really want to see her again, Your Honor. I'm very worried that we're not going to see her again. I truly, truly want the court to hear that this coming in from a place of compassion and concern, not a place of bond violation. This coming from a place for the people of actual concern. We will not see her. I am requesting that the court consider bond change with a release to treatment for her to get some help. But I do know that my experience with this drug and all the education I have surrounding drugs in general leads me to believe this is an extremely risky behavior. I ask the court to consider a bond change.
Please, Your Honor, please.
I do know Miss Fleming does have a medical team around her. She sees her primary care doctor consistently. As I stated, she is in therapy. I think everyone's concern for Miss Fleming is warranted, especially the circumstances that this arose out of. I'm happy to work with her and get information to the people in the court if the court allows her to stay out of custody. Obviously, if she's in custody, that will take place too. I'm just asking that the court consider letting us work on that while she's out of custody.
Please.
She does have some medical issues that, and that's partially why she sees her doctor so consistently. This is an old retail fraud. I do, it's this case, I don't believe has anything to do with her use or anything like that. I just asked for a chance.
It might though, because if she's been using for off and on, as she's indicated, a year, this offense is in June of this year.
I mean, I don't know exactly how long I've been using it. It's been for some months now. I don't know if it's been a year exactly.
Okay, Ms. Fleming, here's how I know you're an addict. You tell me one thing, and then when all of a sudden that doesn't seem like that goes your way, you change your story. You did that in rather rapid shot fashion when you were on Zoom.
I'm so sorry.
No, Miss Fleming, sometimes things happen for a reason, and not all of them we like what happens, but they happen for a reason. And maybe it also goes to what Ms. Feltes.
Please keep me out of custody today. Please, Judge Simpson, please. I'm begging you.
You can't stop.
I am stopping. I'm done. I promise. I
And
promise
here's
with
my
everything
problem,
in
Ms.
me.
Fleming. Ms. Fleming, here's my problem. You've already lied to me today, repeatedly. Repeatedly.
I am so sorry. I am so sorry. I got here as soon as you said, please to come down. I got right on the bus and I came
It
here.
was either gonna be, and I think you understood, if you didn't come down, we were gonna come and get you because there was gonna be a bench warrant.
Okay. I think you're scaring me straight.
No, I don't think I have. Certainly not yet. But I'm gonna let you know, if you think for 1 minute that I'm gonna sit here when I know what I know at this point and have you die on my watch, and I haven't used what tools I have to try to make sure that you stay alive, you're sadly mistaken.
Please don't take me in today, Judge Simpson. Please, I'm begging you, please, please, everything in me, please. Please give me one more chance, please. Please, Judge Simpson.
And I will add, Your Honor, Ms. Fleming was honest with me when I spoke with her. I think she understands the reality of the situation.
Anything else you want to tell me?
Just that I'm going to tell you the truth from here on out. I swear on everything in me. I swear on everything in me, Judge Simpson. I swear on everything in me. And I voted for you.
Doing about the 65 other thousand, but thank you. You're not dying on my watch, not tonight.
I'm not going to die
I'm
tonight.
done.
Please.
I'm done listening. Listen to me now.
Okay.
You're not going to die on my watch. I can't trust you. I don't know what therapeutic routine you have, what you have surrounding you that I can safely let you out. Because whatever you're doing at this point, you do it, you go home and you're huffing.
I won't,
Yeah, I know, you're gonna tell me I won't do it. You're gonna tell me that all that
please, Judge
stuff.
Simpson, please.
Miss Fleming, I've heard it all before. And then the next thing I